Mpanga Advocates. I'm going to be your moderator this afternoon. Also, to take us through this series, The Latest in Law, we have a panel that I will introduce shortly, but for the benefit of those that might not be aware or joining in for the first time or interacting with this amendment for the first time, I will just give a brief introduction to our topic of discussion, and then I'll proceed to introduce our panel and we'll get started. So thank you very much for joining again. So as a way of background to our discussion this afternoon, we'll be discussing the Computer Misuse Amendment Act of 2022. To those that are aware, on 14th of October, the President signed into law the Computer Misuse Act of 2022. And this amendment seeks to amend the Computer Misuse Act of 2011, which was enacted to enhance safety and security in the increasingly digitized environment, including, for the Act, it included prevention of unlawful access, abuse or misuse of information systems, including computers, and securing the conduct of electronic transactions. So the Amendment Act now, according to its long title, seeks to enhance provisions of the Computer Misuse Act as it stands, and then to enhance provisions on unauthorized access to information or data. It also seeks to prohibit sharing of any information relating to a child without authorization from their parent or legal guardian. It also seeks to prohibit sending of information which promotes hate speech, provide for prohibition or sending of sharing information that is false or malicious in nature, or of unsolicited information generally. So that is really a gist of the Computer Misuse Amendment. And according to its promoters and according to Parliament, it seeks to address evils of misuse of online and social media platforms, as well as communication, and also to address evils such as abuse towards children through sharing of images and without consent. So that was just an introduction to set the scene into our discussion this afternoon. And it's my great pleasure to introduce to you our panel that is going to handle this subject that's of great importance and very relevant to many. And so it's with great pleasure that I'd like to introduce to you our keynote speaker this afternoon is going to be Mr. Isaac Semakade. He is an advocate and the founder and CEO of Legal Brains Trust. He's had a long career as a lawyer and a human rights defender. And he likes to describe himself as an anti-clockwise thinker and a legal rebel. So Mr. Isaac Semakade is going to deliver the keynote address in respect to our topic. And then later on, we have a panel that will then discuss the gist of the law and break it down for all of us. And later, so we'll hear from Professor Anthony C.K. Kakoza. Professor Anthony Kakoza is a partner at Biencha Chihika and Co. He's an intellectual property and cyber law expert. He is a former dean of the Uganda Christian University Law School. He's a visiting professor in several universities. Professor Kakoza is an advocate of the High Court, an accredited arbitrator and mediator, and he's worked with several projects in the IP space and has, in just the recent past, been very instrumental in making presentations towards this amendment. So we'll hear from Professor Kakoza later on. Our second panelist is Ms. Catherine Anite. She's a lawyer, a media law activist, and a founder of 4Hub. Catherine is a senior programmer and officer, media safety and protection at Article 19 East Africa. She is hugely engaged in media law, media practice, media engagement, litigation, and everything about the media. And so it's a great pleasure to have Catherine on our panel this afternoon. Just 1 minute housekeeping rules. We'll have the chat room open for engagements as we go along. So feel free to engage the panelists and our presenter as the presentations go along. But later on, we'll also open up the room for questions, for engagements, for as many people as possible that can share their views on this important discussion. Right. So with that said, and without further ado, Isaac, I'm going to invite you. Hello and good afternoon or good morning, since you're joining us from somewhere else. We're looking forward to hearing from you regarding this amendment.
Thank you very much, Ms. Misuse, for that introduction. I hope I am clear.
Yes, you are.
All right. Good afternoon, colleagues and comrades on the call. It's my great pleasure to address members of the bar and freedom of expression advocates across the world interested in this discussion. I am going to go over without much detail, the provisions of the Computer Misuse Amendment Act of 2002. I will leave the intricacies of those provisions largely to my co-panelist, Professor Kakoza, because he submitted an elaborate presentation before the Information and Communication Technology Committee of Parliament during the passage of the bill and has been observing it. And also because I want to speak broadly on certain aspects, 5 aspects that will lay out the problems, the solutions, and the options at our disposal now that this act is passed. So without much wastage of your time, I want to say that I think, Mercy, from your introduction, there are 2 provisions of the act that you left out, and most people may not be aware of them. That is the insertion of Section 26D in the Principal Act titled Misuse of Social Media. And that section has a paragraph 5 which attempts a definition of social media, meaning a set of technologies, sites, and practices which are used to share opinions, experiences, and perspectives, and includes YouTube, WhatsApp, Facebook, Instagram, Twitter, WeChat, TikTok, and so on. So the favorite sites that we know there are stated. I would like to say that by incorporating these definitions, I think the general law, which is company-made law for these institutions, is being incorporated in Uganda law. And we are going to see how that will interact, because these are communities with specific law that has really attained ubiquity and notoriety across the world. And it's good to see how they are going to interact with national sovereign jurisdictions. As you know, some of these social media websites make specific promises to their community members, like guarantees of encryption, And they also give assurances of mutual legal assistance to sovereign governments based on their terms and conditions. So Mercy and others in corporate law do expect challenges involving contexts between these institutions which are aggressive promoters of their brands with local law enforcement actors. I think Mr. Fred Mwema, one of the leading advocates in Uganda here, was through the first salvo in Ireland when he sued Facebook. And we saw this happen where Facebook sought certain privileges in the course of a defamation suit. It sought to be relieved of a duty to make disclosure to Mwema because Mwema was interested in information specific to users in Uganda, which, according to Facebook, it was reluctant to make because the information available to Facebook was that Uganda was notorious for violating the human rights of digital users, and Facebook could be liable under EU law for endangering the rights of its users by handing over their identification data to a well-known rogue actor. So that is the status of Uganda. I don't think we have improved later. I will speak later on that. So I think you had left that out, but it's for good reason. This section was smuggled in at the tail end of the process. It was not included in the bill at first reading. It appeared, it was inserted by the committee, the majority of the committee at second reading, and then passed with very few modifications. What this means is that people like Professor Kakoza, the Uganda Law Society, and all other stakeholders who made presentations on the bill after its first reading and after its gazettement, first reading, and when it was before the committee, did not have a chance to make presentations on this newly inserted section 26D. Similarly, and we are arguing in one of the suits that we have filed that was a defect in procedure. It deprived stakeholders of adequate public scrutiny. So the bill did not receive adequate public scrutiny due to an unreasonable criteria or procedure followed by Parliament or its committee. And that therefore it should be nullified for that ground. The second amendment is the deletion, the repealing of section 30, subsection 3. Again, the Nsereko bill did not propose deleting section 30, subsection 3, if I recall very well. Yeah, it didn't. So this, again, was an innovation of the committee, which was not presented to the public for scrutiny, consultation, and public participation. And we've argued that it is not appropriately justified. What is section 30, subsection 3? Section 30, subsection 3 of the Principal Act of 2011 limited state authority in the following terms. It limited the enforcement of the Computer Misuse Act to the territorial jurisdiction of Uganda. That is to say that before enforcing any of the provisions of the Computer Misuse Act, any person or authority interested in such enforcement had a duty to show that the alleged perpetrator or the alleged device, that is the computer or program or data, were located in Uganda at the material time the actions complained of occurred. Your law reports will show that in the landmark case of Stella Nyanzi versus Uganda, criminal appeal number 79 of 2019 and criminal appeal number 80 of 2019, the cross appeal by the government, both the prosecutor, in fact, the investigators, the prosecutors, and the magistrates court at Buganda Road Court, which is the designated trial court for Computer Misuse Act, in terms of the statutory instrument that the government passed sometime a while ago, designating that court as the Standards, Utilities and Wildlife Court. They were unaware of the implications of Section 30, subsection 3. Or if they were aware, they had observed it only in breach and gotten away with it until they were held accountable in the Stella Nyanzi case. In the Stella Nyanzi case, which I had the opportunity to argue together with my land colleagues, Derek Bazeketa of GM Advocates, and Gerard Owini, we were able to persuade the High Court of both the procedural and substantive safeguards that motivated Section 30, subsection 3. We surveyed global literature, which showed that the following two aspects of a cybercrime that distinguish a cybercrime from any other crime. Number one, a cybercrime is committed on a computer. It's the Computer Misuse Act, for God's sake. And the computer is an identifiable device. Identifiable in the sense that technology today exists to identify a computer by several particulars, including, for instance, if it's a phone, an IMEI number. If it's a laptop, anything else, you have things like IP address, and so on and so forth. And the second thing that distinguishes a cyber offense from any other is that a cyber offense is a location-based event. The technology that is readily available today can establish to the precise coordinates by longitude and magnitude and other metrics, the precise location of both the computer or perpetrator or data or programs involved in the commission of an offense. And this location is of critical significance because, and this is very, very important for those of you who practice criminal law under this act, because in the digital age, seeing is not believing. What may appear, as Professor Tony Kakoza writing to you from Kampala, may actually be a different thing. Now, those phenomena are several. Literature to that regard is immense, and we were able to traverse it and show it to the court. And I think there have been some authors on this subject, like Professor Kakoza, who is here, who can speak more, who can articulate things like SIM cloning, deep fakes than I can. So I will not engage into that. I just want to ensure that we showed the risk that Parliament was aware of when it said that, when it required government to specify both the computer and the location before assuming or seizing jurisdiction. And we were also able to show the court that for a government authority to establish this, to pass this test, the jurisdictional test, it has to engage in what we call a forensic inquiry and produce a forensic report and submit this forensic report before a magistrate in advance of even summoning a person. Because even the court, without reviewing a professionally produced forensic report, has no jurisdiction to issue a warrant, to issue a summons and compel maybe the attendance or arrest of an accused person. And it's grossly unfair to accuse a person only to find later that the person was the victim of the various phenomena that can lead to misidentification and misattribution. We have worked one of the cases here called Uganda versus Robert Shaka, and others, I think. But that particular case showed us that the government of Uganda had arrested up to 26 people, Shaka being the 26th, in its search for an internet user called TVO, Tom Voltaire Okwalinga. 26. Completely based on unreasonable suspicions because they were avoiding the duty to conduct a forensic inquiry. They have the forensic expertise at the Government Analytical Laboratory and in their media and political crimes unit and so on, cyber crimes unit. They have the ability, they have the resources at the Uganda Communications Commission, and they could, in fairness, apply for a mutual legal assistance via the terms and conditions of the various social networks. But I think in vindication of the land judge sitting in Ireland in the case of Moema, the Uganda government either did not try to invoke any of its rights under the terms and conditions of Facebook, or in that case of Robert Shaka or Stella Nyanzi. They didn't even try. So the Stella Nyanzi case was therefore, the result was that the proceedings in the lower court were quashed, set aside, because on the ground of failure to establish jurisdiction. And once there is no jurisdiction, all proceedings are in nullity. Now, it is against that background that you see the government of Uganda, without any justification and in a secret manner, it is passing law to reduce its burden in enforcing the Computer Misuse Act, so that they can catch any person and that person doesn't have adequate procedural substantive safeguards. You will be inconvenienced through a trial where the government will ultimately fail even to properly identify the alleged perpetrator. And it, of course, it deprives you of defenses like alibi. Now, I am going to use a vivid example involving the current DPP, Jane Apodo, and how she abused the existing law, so that you can understand this context. So, Mercy, thank you for the introduction you gave. And it clarified exactly the state of knowledge we have. The other provisions, Dr. Kakoza will speak broadly upon them. I will just make one view that they don't pass constitutional muster based on the usual tripod: vagueness, overbreadth, and lack of sufficient clarity required for criminal offense. And of course, they also prescribe offenses. They also prescribe sentences that are more than proportionate, more than adequate to meet the harm. Of course, the government, in the passing of these laws, did not adduce any evidence to justify the necessity of these laws. I think Professor Kakoza will be the best person to speak to the abundance, the adequacy of alternative, less drastic, less tyrannical regime. Why rush to criminalize? Yet resorting to civil recourse would have been adequate remedy for all these things. I will stop there for now and go on with the rest of the submission. So Professor Akoza and my colleagues will discuss in detail those other provisions. So these are the 5 things I want to share with you. 5 matters for discussion, assuming, of course, that those on the call have listened to sufficient analysis about the other provisions of the past law. The first and main issue is whether the passing and making of this law was consistent with state obligations under the Constitution of Uganda, in particular Articles 29(1)(a) on freedom of expression, and the decision or decisions in Obo and Andrew Mwenda versus Attorney General, Constitutional Appeal number 2 of 2002, together with the decision of Andrew Mwenda of the Constitutional Court in Andrew Mwenda and East African Media something later on, plus the Article 38 on public participation in lawmaking. We submit that the passing and making of this law was inconsistent with these state obligations. Procedurally and substantively, the passage of this law is grossly defective. I'll leave the finer details and intricacies, niceties for my colleagues to engage with, but suffice to say that I've shown you, for instance, that there was inadequate public participation. One version of the bill, in fact, a substantial volume of the now gazetted law was not made available for public consultation. It was withheld until the close of the public scrutiny stage. Then it was introduced Number two, there was inadequate time, even within Parliament. Given this radical step of introducing new clauses, there was inadequate time given, even in Parliament. I think it was a few hours to discuss everything and vote on the two reports. You see, there were two reports raising very diametrical opposed arguments. There was no requirement to go forward, but a vote was called. Those who have read the Hansard have found the scrutiny of the whole House, unreasonably short of the constitutional standards. I think Parliament, each member and Parliament as a whole, they owe us a duty to be awake and alive to constitutional safeguards in lawmaking. You cannot just legislate irrationally, impulsively, simply because you can marshal a majority. I think it is stated very clearly in the landmark case of Severino versus Attorney General. How should a parliament in a constitutional democracy behave? Can parliamentarians, conduct themselves like a mob? That question has been answered before in Severino, and we hope it will be answered again in the suite of cases that people are filing. That is procedural health. How about substantive? Like I've said, I will leave much of that. I will speak some of this as I go further, but I'll leave the final detail to Professor Kakoza and Madame Catherine Anite, who are also equally able as I am, if not better. Did the passage of this law meet the requirements of the East African Community Treaty in Article 6D and 7, sub-article 2? The requirement of good governance, adhering to standards of democracy, rule of law, transparency, accountability, social justice, and the maintenance of universally accepted standards. The government of Uganda, as you are all aware, Uganda is a state party to that treaty. And therefore, its laws must be consistent with the treaty. And this law touches freedom of expression, which it is common cause, is the foundation of democracy. In the landmark case of Burundi Journalists Union versus the Attorney General of Burundi, a case which I invite all of you to read, particularly, this is a judgment of the East African Court of Justice from paragraph 74 to 85. That is for jurisprudence. The East African Court of Justice laid out principles which rhyme and chime with our leading cases here on freedom of expression. The long and short of which is that the litmus test for assessing the propriety of a law that affects freedom of expression is the same. It is the test in Ara versus Ox. That is the proportionality test. And the test in Ara versus Big Drug Mart. Those two leading Canadian decisions, Ara versus Big Drug Mart, the purpose and effect test. Despite the whatever the good intentions of the law, the court is interested in the likely effects of the law if improperly administered in the hands of the wrong person. Is this a blunt instrument? is the law finally tailored such that even the most malevolent actor finds themselves without a weapon to harm innocent mercy? If the answer is that the law is not finely tailored, it doesn't have internally built controls against abuse, it must fail. So we've argued broadly that the pretexts of protecting child welfare, privacy, hate speech, unsolicited information, malicious information, misuse of social media, these sound like welcome, objectives, welcome purposes. But when you study the fine text of the law against the context in which the existing law has been applied, against the human rights climate in Uganda, the rating of law enforcement standards in Uganda, you can't help but come to one conclusion: that the law will have deleterious effects, unsalutary effect. It will have chilling effect on not just political life, but economic vitality and social interactions. And therefore, it will dim democracy. It will not increase democracy. That is the argument we are making in a number of cases that we are supporting locally and internationally. Does the law pass the test in the African Charter for human and people's rights, particularly Articles 9, 13, and 25? Article 9 is on freedom of expression. Article 13 and 25 are on public participation, where the people sufficiently educated, given the tools to be aware of the law and the direction government was going? We don't think so. That duty is on government. This law was rushed through, the procedures of parliament and so forth. There is a decision of the African Court of Human and People's Rights called Issa Lohe Konate versus Burkina Faso. This decision specifically invalidated criminal defamation laws in Burkina Faso. And number one. Number two, it also included a determination that criminal penalties, as a general rule, were inappropriate for speech-related offenses. And the government faces a very high bar to justify a criminal penalty of any kind in a speech-related offense. Because if what you want to prevent is the impact of speech on particular individuals or groups, civil recourse may help and has been shown to help. So the government of Burkina Faso was required to amend its general law and comply with this standard. Now, and Uganda is a state party to the charter. So this decision binds Uganda, according to one of the articles in the charter. Uganda must support the organs, including the court. Although Uganda has not deposited a protocol that permits us to have direct access as citizens or NGOs from Uganda to the African Court, challenges can be taken to the African Court through the African Commission, which will then act as our litigant before the African Court. That remedy is still available to us to test, among others, whether it was even necessary. Haven't we rushed to criminalization before testing the viability or otherwise of alternative remedies. Last but not least is the International Covenant for Civil and Political Rights, particularly Article 19 on freedom of expression and Article 25 on public participation in the lawmaking process, and together with General Comment number 34 and 25, respectively. We say that these fines, norms, and standards have been violated procedurally and substantively. The next logical question is, what are the options? Well, nullification and interim measures may be sought from the national courts and regional tribunals, including the East African Court of Justice, the African Commission, and the African Court, which are based in Arusha, and the Human Rights Committee of the UN. And I believe from the chat I'm receiving within the trenches, efforts are in high gear to go everywhere. I want to speak briefly on this issue about the politics, logistics, optics, and schematics of these options, particularly for the Uganda Law Society. The Uganda Law Society is already in court before the Constitutional Court of Uganda, Constitutional Appeal number 1 of 2019, challenging the constitutionality of sections 24 and 25 of the Computer Misuse Act of 2011. There are other actors in that court, including unwanted witness and the client of Mr. Rakafuzi Swaibu Gojolonga. Then there is our petition of Robert Shaka and Andrew Karmaji, and many others which have been reheard at least thrice, purely out of poor case management in the Constitutional Court. Panels are presented, they hear the matter, and then judgments are not presented within 60 days. You learn later, a year later, that they are calling you back for, rehearing. Just early this month, we received a new set of submissions from the Attorney General, October 3rd, for a petition we filed in 2016, the very first petition. So that is something speaking to, how we manage administration of justice. Uganda State is represented by currently ENS Africa, and they wrote a letter to the DPP. No, I think it was the president, Fiona Wall, who wrote a letter to the DPP asking the DPP to, letter dated 15th March 2022, to the Director of Public Prosecution. The President of the Society, then Fiona Wall, was requesting that in light of our petition pending for the Constitutional Court together with other petitions, the position of the law is clear. In Olaro Tunu versus Attorney General, Obo versus Attorney General, when all criminal proceedings under any impunity provisions of law should be stayed pending constitutionality. Can the DPP administratively, in the interest of orderly administration of justice, halt these prosecutions? We know that all accused persons, not all accused persons have had the means or privilege of filing constitutional petitions, nor seeking stay of the respective prosecution. Can you, at least in the interest of justice, stay these trials for them? This letter went unanswered. An appeal for a proactive step to forestall potential miscarriage of justice. That is good to keep in mind. So ULS really has done its best, but its reputation is in tatters still. I don't see how it can avoid maintaining eternal vigilance. ULS did not challenge internet cuts during the first election. ULS has not campaigned for the presentation, for the composition of the Uganda Communications Tribunal under Section 60 to 65 of the Uganda Communications Act, where most of these disputes would be fought as civil disputes, not criminalized, not criminal penalties. So ULS has more to do. I think since we have a new energy, we need to look into that. Apart from going, it will not profit the ULS to file another petition, but as I will propose later, to look holistically at the digital environment and see how ULS can reboot and reboot digital safety and security for all stakeholders and communicate the essential confidence to the market. Again, it is my wish that political parties, media organizations, and businesses can calibrate their interests and provide testimony that is unique to them so that the court can make appropriate harm analysis. This culture is not present in Uganda yet. A lot of these organizations, which are the most which benefit the most, they tend to outsource the litigation, the defense of these rights to Kathy, Tony, and I. Kathy and I from the civil society, and Tony from academia. And yet we don't have the resource baskets or even the interest to continue or to push these things with time. That's why we filed the challenges against POMA in 2013, and we got ruling in 2019. Yet, why? It was because it is not the people who are making these gatherings that file, who need these gatherings the most. Civil society has done its part. It challenged the Anti-Homosexuality Act, Anti-Pornography Act. All these challenges civil society have been successful, but they haven't been successful in time for those who take immediate dividend, largely because those who own their agency tend to slip through these things. So that is what I suggest at that point. I think ULS must calibrate its interest properly and choose the appropriate tone and content moving forward. For us as civil society, we have our interests and we have safeguarded them properly based on the news reports you may have had. The third thing I want to speak about is that we need to appreciate the extent to which we are vulnerable and the ways to defend ourselves against such harm. The 36th president of the US, LBJ, Lyndon Benjamin Johnson, once said that you should not examine legislation in light of the benefits it will convey if properly administered, but rather in the light of the wrongs it would do and the harm it would cause if improperly administered. I submit that we should heed this advice when examining the Computer Misuse and Amendment Act of 2022, not least because it is consistent with the litmus test in Obo versus Attorney General, Burundi Journalists Union versus Attorney General. That is the purpose and effect rule, which says that we must, says, and I quote, intended and actual effects are often the best indicator, the best guidance in assessing the legislation's object and thus validity or invalidity. the law's good intentions carry no meaning, carry no weight. It is the intended and actual effects that provide the consequential test. And I think that's what LBJ was saying. LBJ is the president that I think assumed leadership after the death of JFK. He was appealing to it was a difficult time, but I think he was responsible for passing the Civil Rights Act. And he was very clear, appealing to the southern states to be very careful about the language they were asking for in the Civil Rights Act, because things may turn against them. This is a warning we all need to take into account. We should therefore not view this law in light of the benefits it will convey when properly administered, but rather in light of the harm this blunt instrument will cause to the safety and prosperity of Ugandans. Some people among you here on the call may think that this law is going to target only politicians, activists, influencers, loudmouth, busybodies, and so on and so forth. But no, according to this law, and as I've told you, the setting in which this law is coming, the rich and powerful, the well-coordinated, the well-connected are going to run roughshod over all of you. I have seen firsthand while representing students and staff at Makerere University that the university administration conducts massive surveillance of their off-campus activity and bases on that to interfere and disrupt their academic progress. Students, and for staff, the same thing. So this is surveillance in the academy, where academic freedom is supposed to be, where social interactions are supposed to be the most free. It has been the sole preoccupation of the office of the Vice Chancellor to enter WhatsApp groups, to spy, to conduct a massive spying operation on students and staff, and stifle even the most basic interaction of students and staff. So out of ignorance, you may not know that this thing is nearer to you than you imagine. You can imagine a thing like unsolicited information. I think I leave those details for others to speak about. But I am going to use a few examples to show you just how much abuse police, DPP, magistrates, and judges can do using this blunt instrument if they choose to conduct themselves improperly against the less fortunate. This law, in my humble view, and I've argued this before, you may remember very well on February 17th, is exactly the sort of instrument through which dictatorships work. This is how tyrannies emerge. This is how tyrannies mobilize the silence, the consent, the inaction of the elite, erudite, and willing. In the Holocaust literature, they call all of you here elites, they call you the enthusiasts. Even Hitler had them. Even apartheid had them. Every tyrant, every mode of governance has always had the cream of the time, providing enthusiasm for bad laws that in the end derailed, depressed, and led to the collapse of those civilizations or those governments, those forms of governance. So the point I'm making is that there's going to, if unchecked, there's going to be so much disruption on campuses, schools, workplaces, because this law then permits such intrusion into your privacy. As an employee, your comments about the employer previously lacked jurisdiction, But now the standard has been set so low that the employer can use police on you. Or vice versa, employees are going to disrupt the workplace by calling police on employers over what would otherwise have been office banter, canteen chit chat, and so on. In churches, in political and social platforms, and so on and so forth. Personalization, tips and beefs are now going to become the subject of calling the police. We are going to see the collapse of society, of democracy, of cohesion, and for Mercy and your colleagues in the corporate sector, free trade itself, as I will show you. Let me give you a classic example of abuse by the DPP. You may or you may not have heard of the case of Jared Okello. Jared Olo Akum. This is a Kenyan citizen who was recently convicted and reportedly sentenced to 2 years imprisonment by Chief Magistrate Kamasanyi Gladys Musenze, who sits in the Standards, Utilities and Wildlife Division at Buganda Road Court. This is a Kenyan citizen who sent 2 emails on the 15th of September 2021 and on the 2nd of November 2021. Allegedly, he sent 2 emails to the DPP to her official address, jane.abodo@dpp.go.ug. Of course, he was complaining about a certain case in which he apparently lost a car, and the Ugandan law enforcement authorities, in his view, did not rise to the occasion of protecting the right to property. In his view, they provided the cover-up, and he sought, as he should have, a remedy from the DPP seeking fresh investigation, which is the constitutional duty under Article 120, Sub-Article 3A. Now, what happened is that the DPP flipped the script on this unsuspecting member of the public, and she constituted herself as a victim of cyber stalking and offensive communication. She actually came to the court and testified that she felt threatened by emails and attachments he had sent. Now, we are all users of these services, and you could very easily block a particular email. She could very easily have had a wide range of alternative remedies to prosecution, but she chose to abuse the power to prosecute. Now, why do I call this abuse? This charge sheet that I'm looking at was presented before Kamasanyi on the 4th of April 2022, when the old law was still in operation. And as I've explained, Section 30, subsection 3, required the prosecutor, the investigator, the magistrate to clarify venue before proceeding further. This is how this charge sheet reads. Cyber stalking contrary section 26. Particulars of offense. Olo Jared Akumu, on the 15th of September 2021 and on the 2nd of November 2021, from an unknown place, clear violation of section 30, subsection 3. Clear violation of standing verdict of the High Court in Stella Nyanzi versus Uganda Criminal Appeal 79 of 2019. But most importantly, clear violation of all the constitutional safeguards under Article 28, Sub-Article 3, and Articles 126. Read together with Article 120 on the DPP, who should be a neutral arbiter. The DPP now was inserting herself. Was sufficient scrutiny made by the sanctioning officer who sanctioned this charge sheet? Her subordinate, presumably, her subordinate. So that then did the magistrate give appropriate scrutiny? Your guess is as good as mine. We are filing a revision on behalf of this Kenyan citizen because he was even entrapped. He was tricked to come into Uganda to receive a service, and the service he received was arrest, prosecution, detention, and the worst form of justice. You will see the record for yourselves. So if the DPP is a malevolent actor, this DPP, this is a clear case of what you should expect moving ahead. This law, this amendment is going to incentivize the rich and the powerful, the well-connected, to avoid any other remedy at their disposal and instead muzzle and punish those that they, make them feel threatened. That is the standard. Disturb the peace and quiet by sending threatening emails. Now, the particulars of the threat, apparently the man threatened, as he should have, to expose her as a corrupt person. That is entirely within his mandate. And that is the risk Jane Abodo assumed when she took up public office. But this here is Exhibit A. Exhibit B is in cases like those of Stella Nyanzi and Kakwenza, where complainants, the alleged victims, don't even present a complaint. In Stella Nyanzi's case, we waited for 9 months to get a complaint from the president of Uganda, and there was none. The only complaint on file was by Grace Akulo, who couldn't even come to court. But that was the settlement. She was saying that, she opened up a general inquiry file in the anticipation that the president would have been offended. This is the evidence on the record. And a lawyer was brought, Mr. Oponya, from the Pornography Control Committee at the time. And he tried to make this as part a private, part public complaint. No, he was trying to say, that he was complaining on behalf of the president. I saw him on TV. That's what he said. His eyes were like this, so wide. I saw a man in pain, and I said I must move. So we asked him, you moved as who? Did you move as the committee, Pornography Control Committee, and did you perceive a pornography offense? Or you moved individually as Oponya? Complete confusion. He was speaking from both sides of his mouth, as they say. Kakwenza was arrested, detained, tortured. Up to now, his lawyer tells me he hasn't received a complaint. The case is supposed to be going forward. Kakwenza's leaving jurisdiction does not stop the case from going forward. Evidence can be laid. He has a lawyer on record. There's no disclosure. We don't have a testimony. We don't have a statement from General Muhoozi saying that he felt offended and attacked in his privacy and peace and quiet and so on and so forth. So Exhibit C is the case of Mekako or Carolite. a young man, age 26, who is a storekeeper, is entering his 60, is making 60 days in detention. He recently appeared before court, this very court, Kamasanyu court, and the state attorney stood up and said that the file has been taken to the speaker for perusal and to extract her statement. So he was arrested, detained, in the anticipation that the speaker would make a complaint. I tell you that the speaker has no complaint to make, and she will have no complaint to make. I know this from experience, where another MP, a woman MP from Western Uganda, had caused the arrest, detention, and prosecution of Brian Isiko over the so-called 1,000 love messages she had received from him. And she said she was, a victim of cyber stalking, harassment, and offensive communication.
Isaac, pardon me to
Yes.
interrupt your presentation, but could you just go towards your wrap up so that we can bring in
all right. So when the case of Isiko was called, you all know what happened. The MP refused to turn up to testify, and so forth. So when you review some of these judgments, you realize, like those of Kamasanyu, who has stayed longest in the Standards, Utilities, and Wildlife Division, you realize that Uganda, there is an emerging feeling that Uganda is a theocracy or an autocracy of judges and prosecutors, contrary to Article 7, non-adoption of state religion. In this, I think in the Stella Nyanzi case, where we had a judgment from her, she limited her review of the content to very religious and moralistic realm, completely eschewing democratic principles of tolerance, broad-mindedness, and pluralism, the diversity of views and opinions, and so on and so forth, being as a necessary lubricant for democracy. Another exhibit is that of Susan Namata, who was in detention for 4 months at an ungazetted place.
Let's try and conclude.
Yes.
We'll get towards the conclusion, please.
I hear you. I just want people to understand the danger. So this was an accused person for whom the state couldn't account where she was, and yet it was preventing a bail application. According to the lady, she was in the custody of the investigating officer. This is sexual harassment. I'm going to preserve the name of the IO for the time being, but you know the case. And sadly, when these facts were laid before a lady magistrate, Stella Maris, she could not conceive the harm in even gender terms, because she was blind to all these things except the letter of the law, and not the effects and enforcement and the effects that were playing out. There are many other examples I would give, including my own, but suffice to say that the warnings issued by Justice Byamgisha in case of Obo, Attorney General, that we cannot leave prosecutors with unlimited discretion to determine what can be said or not said by members of the public. That isn't democracy. The last exhibit in this regard is the recent report of the Human Rights Watch, I Only Need Justice, of March 2022, where there is abundant evidence of, torture squads, death squads, and abductions, and so on. And all these are the results of surveillance, digital surveillance. and they are targeted at digital users, repression of digital activity, and so on and so forth. So this is very important to understand. The other harm here I need to stress is that in Uganda, we over-arrest people. This must stop. We need to decolonize, transform, and restore dignity in criminal procedure by using the instrument of criminal summons, the delivery of a summons to an identifiable person. We have changed our laws to have the Registration of Persons Act. Everybody in Uganda is identifiable, at least by an ID now. That's the law. And it is the duty of the state to recognize the inherent dignity of each person who has an ID by delivering to, and a phone even, by delivering to them a summons requiring them to attend court voluntarily as the first option, such that warrants of arrest will come to those who are recalcitrant. If we don't remove these performative arrests in the crude attempt to show law enforcement, we shall continue to have a traumatized society. We must destigmatize criminal proceedings. This is a question of orderly administration of justice. Arrest first, investigate later is a criticism and condemnation we are hearing in very few judgments, and often very late. Time doesn't permit me to enter the Security Organizations Act of Uganda, but that act prohibits intelligence agencies, ISO, ESO, and others that government may set up under an act of parliament from conducting an arrest. But they continue to do these arrests. The UPDF Act and regulations have some of the best safeguards before one is arrested for persons subject to military law. But those safeguards are observed more in breach. A person subject to military law must be investigated when their dignity is respected, and only arrested after a certain organ has sat and determined that presentation before the court martial is necessary. But that doesn't happen. And these standards are not being enforced by courts of law, including the court martial. Therefore, the rulings, the early rulings of Facebook in the Mwema case have been vindicated. I want to say here that to speak about the chilling effect in the following words, that the internet started as a hub for pornography and gaming and gambling. The internet started, it got its popularity, not because it was used by the Tonys, the academia, or us, the elite. No, we were late entrants, late adopters of the technology. But we joined once it became a mass market. It became so the other thing I want to say is that those who seek privacy don't need state protection on the internet. No, they will lead innovations in that direction. They will seek to protect themselves, like already they are doing so. So when we stigmatize the internet space, the pool may dry out. And people this morning were sending me things about Web 3.0, new forms, blockchain technology, new forms of staying away from the mass market to an exclusive market. But that means that bad regulation or bad enforcement is going to create market disruption. The internet has become a marketplace, it has become a church, a bank, a hospital. If we make it a crime scene, we disorganize, we hamper the provision of services in that regard, simply because somebody throwing away the baby with the bathwater. The many opportunities we will miss because of trying to promote the right to be shy and to have a low self-esteem. That is a danger, a massive danger. The last danger, of course, is the damage to the law, institutions of law. As you have seen, the DPP caught with her hand in the cookie jar in a massive abuse of law she's supposed to implement fairly. What happens to a society whose institutions of law have lost all honor and the public have lost high regard? I leave that for you to answer. Mercy, sorry for spending time, but let me just touch on the fourth and fifth and close. Fourthly, this act reflects the demise of the best ethos of public service, because it is giving undue attention and weight to people of low emotional maturity. Let me give you an example or two. When you read those provisions, you realize that the act encourages people to take things personally, to feel personally attacked very easily. This is a wrong purpose or effect of law. In a democratic society is no place for someone who is unable to put their ego aside. It is no place for someone who is unable to have a vulnerable emotional connection because they have a fragile sense of self. You have a duty to receive robust, uninhibited speech, even one that offends, shocks, and annoys you and ridicules you. This act fails that test. It changes, it completely upends the pillars of democracy in that regard. This act promotes people of black and white thinking, people who have inflexible opinions, ideas, and beliefs, people who have little or no tolerance for the opinions of others. The phrase, "This is the stupidest thing I've ever heard," "You are the stupidest man I have ever met," "You are the stupidest leader that has ever led this country," is going to become criminal. How did we arrive here? This act promotes people who are so self-centered that they bring everything back to themselves, and it is how they feel that should be the law, the standard of proper conduct for the rest of us. People who need validation, affirmation, and lack all sense of curiosity. They lack humor, a sense of humor, and so on. This act is encouraging people who are dismissive of the diversity of our society. It is encouraging people who are highly defensive, who are unable to listen to the thoughts, feelings of others without being defensive. And therefore it is dangerous. Lastly, in terms of solutions, moving forward, we need to relaunch a duty council program. There used to be one by the Law Society, but one specifically targeted at the standards, utilities, and wildlife division, because people who can't afford legal representation or who have inadequate or ineffective legal representation are railroaded there daily. The Uganda Society and the civil society of Uganda need to find a way. We need the support of members of the ULS. We need allies to assist people at that court. It's just one court. We give them combative criminal defense, just to avoid scenarios like Olo Jared Akum recurring. At Legal Brains Trust, we are committing to this legal aid program, but we shall need volunteers and we shall need your resources. We shall communicate further. We also need to expose the history of abuse. I think some people don't understand abuse, and that's ignorance is acceptable. So we need to look into the history, the 11-year history of enforcing the Computer Misuse Act, and make this and conduct a thorough research. The research department of ULS can help us do this. Conduct a thorough research, account for every case. Let us see what was the charge, what was the pre-trial procedure, what was the judgment, how did the trial proceedings happen, what was the judgment, what was the sentence, what were the post-conviction and post-sentence remedies, if any, and do all these things pass constitutional muster. Let us conduct that research. This is a message to Mr. Bernard Owundo and colleagues at the Bar Council now. We could even interview some of the clients, court users who pass through this experience, and we hear their views. Lastly, we need to look at Uganda's whole digital infrastructure. Yes, I think I'm concluding. The government of Uganda has a program of rebooting its entire communications laws, but it's happening behind closed doors. Uganda society and other freedom of expression advocates need also to convene their own think tank and look at the digital infrastructure holistically, rather than these knee-jerk reactions. I beg to submit. Thank you.
Thank you very much, Isaac, for a very, very thoroughly researched presentation and paper. For those that joined much later when we were introducing Isaac, I think I forgot to mention the fact that he's also a very good researcher and writer. And so, Isaac, I hope that your paper can be available for members of the fraternity and also members of the public to read, because along the way, some people were asking for citations to authorities and all. But thank you very much for a very, very insightful research paper and presentation. It's been in depth, and the breadth of it cannot be summarized in a few minutes, but it certainly goes over and beyond what many people are looking at in terms of the amendment of the Computer Misuse Act. And I like the fact that you have drawn lessons, experiences, and examples from all over the region and the continent, which gives it even more richer relevance to the discussion that we're having. And so, colleagues, that was a presentation, a keynote presentation by our very own Isaac Semakade in respect to the amendments to the Computer Misuse Act. And a lot of things he's brought out through his paper, issues regarding procedure in legislation and legislative, passing of laws, issues in respect to constitutionality, criminal procedure and proceedings, civil questions for each and every one of us, using examples that take the point home that no one's safe in light of amendments such as this. So, Isaac, many thanks to you for such a wonderful paper and presentation. And so I was reading some of the comments, and some people say they could listen to you all day long. I agree. But we have a panel that I would like to loop in now, also to weigh in on the amendments, but also to respond to some of the important questions that Isaac has raised in the course of his presentation. And I've been looking forward to listening to Dr. Kakoza, who, as we had mentioned earlier, was very instrumental in engaging with the committee in parliamentary in regard to this amendment. And so, Professor, welcome and good afternoon. Thank you for being here. I would like to hear from you your thoughts on the amendment and your thoughts and any responses to what Isaac has raised in his very, very elaborate presentation. Over to you.
Okay, thank you very much, Marcy, and thank you, everyone. Indeed, I thank Isaac as well for a very well elaborated paper. I couldn't agree more with what Isaac has said and his very well researched presentation. I know I have very limited time. I'll try to squeeze my points down to just 10 minutes to allow Catherine to also come in. And probably to start with a summarized phrase, which is the same phrase that I mentioned in Parliament when I appeared before the ICT committee, that what we're looking at is an amendment where you use a sledgehammer to hit a mosquito, because at the end of the day, if you try to hit a mosquito using a sledgehammer, you just decapitate your hand or anything like that. And that's what it's really coming to, which is more or less what Isaac has also been saying. So like I said, I'll try to squeeze it down. And when you look at section 12, that's where the amendment starts off in positioning a new clause of section 12 of the Computer Misuse Act, the Principal Act. It's bringing in a provision where it's talking about a person who, without authorization, accesses information belonging to another person. And in doing that, it becomes criminal. So it expands the liability to 10 years, exceeding 10 years, and then of course paying about 15 million and all this. But you find that this is now gagging people like myself, people who engage in research, people who, yes, value copyright material, but when you turn this into what does the Copyright and Neighboring Rights Act say, it allows for limitations and exceptions. It allows that if someone owns information and another person is accessing it for academic or educational purposes, or a journalist who's accessing this information for the news of the day or matters of that nature, you would not need to get the permission. You would not need to seek authorization, but at least you'd give acknowledgement to the source. But now when you read section 12 as it is, it's putting all this away and it's making us jittery, because we'll be looked at as criminals ourselves if we start accessing information without getting authorization. So in what I also presented to Parliament, I mentioned about the fact that we have these limitations in copyright law, which are now being gagged by the amendment. And I was happy that a minority report was presented by Honorable Namuga. When you read the Hansard in the deliberations in Parliament over the amendment bill, Honorable Namuga brought out a minority report where she was the sole signatory, and she laid out this position, but it was rubbished aside. And then she went on to also talk about something that I mentioned in my presentation, turning to clause 23A of the Principal Act in the amendment, which is talking about unauthorized sharing of information about children. And with this one, the position is that we are duplicating what is already in the Data Protection Act, Section 8 of the Data Protection Act. And we're also duplicating Section 4 of the Children's Act, which talks about privacy and respecting safety and privacy of children. The response or the rebuttal that came from the Honorable Learned Attorney General was that this is not really duplication, but complementing already existing law. But I would rather continue to push the view that we do not need a provision that says you shouldn't share unauthorized information about children, whereas you may find situations where people need to share such information legitimately, but will feel constrained by the new section 23A. So to say that this is complementing is still gagging information that is shared in these matters. And to have it at 50 currency points or imprisonment exceeding 7 years for anyone that engages in such activities is also over and above anything that is imaginable, as Isaac said. So I won't labor so much on that as well. I want to quickly also run to the insertions that are made in sections 26A, 26B, 26C, and D of the Principal Act, starting with the issue of hate speech. So hate speech is brought out in 26A and broken down into anyone who ridicules, degrades, or demeans another person, or B, creates divisions among persons, or promotes hostility against persons. So my argument here is that this is really too broad, and it's removing the criminal issue of intent, the mens rea, because if anyone is found sharing information that leads to activities that are considered as hate speech under this amendment, then you would find yourself having to try to prove yourself out of this. And as Isaac said, you're putting out a law that could be misused by those who are trying to enforce this law. So how are we going to continue, or how are we going to defend ourselves that we're not trying to do any of the three ingredients that are spelled out under 26A? So you find that this issue of lack of intent is spoiling the law. Intent is very important to prove hate speech. In any case, what is hate speech? I'm just trying to argue this out as ingredients under 26A, but that is my own interpretation. Any court would look at it in a different way. So because it has come out too broad, one would argue that we would prefer to remove this entirely. Why criminalize matters of this nature when you have the alternative of posing in a defamatory suit and using tortious liability over defaming and take a person through a civil prison over a matter of this nature? I find this as really dangerous to legislate over hate speech. And because of the nature of the ingredients that are placed here, it's going to be trapping in so many people, which is definitely quite problematic. You find that the Council of Europe has tried to define hate speech, and they use it. They say that this is a term that is used as a broad discourse that is extremely negative and constitutes a threat to social peace. Now, anything would fall in that dimension. Having that in legislation is quite problematic for courts to place a person into a position where they would have to prove themselves out of it. Turning to 26B on unsolicited information. We argued against this as well. So it says under 26B, I'll try to read subsection 1. A person shall not send to or share with another person unsolicited information through a computer unless the sending or sharing of the unsolicited information is in the public interest. So what the balancing that the government is trying to do here is the phrase public interest, that, okay, if you're sharing information about kids that have lost their way or have been kidnapped, that's in public interest, so that is okay. But anything outside of that is wrong. But where does that put family or group or any kind of social communication? Where does that put social media influencers or social sharing of information over Facebook or Twitter or Instagram and the like? As long as you're sending information that is not unsolicited, you would be grabbed in this position. So at the end of the day, it's like telling us not to socialize at all over the social media. That is total and absolute gagging. I think it's Justice Mulenga who once said that freedom of expression should be one of the least regulated principles because no one comes from a neutral point of view. We are regulating over freedom of expression here and stopping people from communicating even in social positions where they would want to laugh over something. But as long as I haven't asked for the information that you're sharing with me, I would accuse you under 26B of having sent me unsolicited information and then have the prosecutors come after you, which I believe is quite wrong. So it's not enough to bring in clause 3 of 26B to say that any information that is transmitted to a person using the internet over matters related to commercial communication is okay, because here the Parliament was trying to connect section 26B subsection 3 with the position in the Electronic Transactions Act, which also provides for unsolicited information, to say that in as long as you send out unsolicited information of a commercial nature, I can continue receiving it, but if I send you communication to stop sending me such information, you should stop. So that's the balance or harmonizing that Parliament was trying to do here. But like I said, it's not enough because people also interact socially over unsolicited information, and they're now being gagged by a provision such as this one, which discriminates against the freedom of expression. So going on to malicious, sorry?
I think could you just address also on that point of unauthorized information on the mens rea? How then is the mens rea in such offense established?
Yes, exactly. I mean, you connect it to the point that I've just made over hate speech, that if the both 26A on hate speech and 26B on unsolicited information are removing the issue of criminal intent, which is quite important in mens rea. Because if legislation is emphatic or clear on intent to having spread hate speech or intent to have spread unsolicited information, just like we see, I believe it's Section 26 of the Electronic Transactions Act. The proof would come out that, yes, you have accused this person of having sent unsolicited information. The intent is there that he did this willingly when he had been warned not to send such information. Therefore, he's culpable for whatever sanction follows. But the way the sections have been phrased here is too broad that everyone, Tom, Dick, and Harry, are being grabbed in and under the net, and that is pretty wrong and will lead to abuse of this law. So the same with 26C on malicious information, sending, sharing, or transmitting malicious information that relates to another person. Why not use defamatory tortious liability cases here? Civil action would suffice in helping out in such matters, as opposed to legislating it and making it a criminal matter. I quickly want to also look at 26D and agree with Isaac. When we appeared in Parliament before the ICT committee, I was representing Uganda Law Society with a few colleagues. When I saw the act as it came out, I was surprised to see 26D on misuse of social media. I was also surprised to see other aspects like the amendment to Section 12, which had not been really discussed as fast. So I really found out that this is really an abuse of the principle of public democracy under Article 38 of the Constitution. If we have a law that is smuggled in this way, would then start questioning the motives behind the law and start assuming that it's going to be abused right from the very beginning. Our government needs to be as honest and transparent as possible in such matters in dealing with situations of this nature. But if you're to gag freedom of expression, then it's going to be really problematic all along the way. Like I said, I really wanted to be brief because of the time spent and the need for questions. So that's it from me. Thank you.
Thank you very much, Prof. And thank you for sharing your thoughts as well on that. And before we get engagements from members in attendance, I'm going to invite Catherine as well to share her views towards the amendment and any responses, any points that Isaac might have raised in his presentation. Catherine, good evening and thanks for being here. You're on mute.
Okay. Can you hear me now? Thank you, Mercy, and to colleagues Isaac and Dr. Tony. As Mercy said at the beginning, I'm a media activist. I don't work for Article 19 anymore, but I do work for Small Media Foundation and other entities. So listening to Isaac and Tony, question pops in mind. Do we have rule of law in this country? Is it rule by law, or are we heading towards rule regardless of the law? And I mean, when Isaac spoke about, the principles under the East African Treaty, the president and a lot of politicians here are always talking about integration. Are we going to integrate with other countries within the region when our principles of democracy, human rights are not, on the same page? So that is a question that, the leaders need to address before we speak of integration, much as we want to improve on the economies. If the human rights of the people is trampled on, then we're not achieving anything. Sorry, I'll just switch on my video because of the bandwidth. But by and large, I think it's obvious that the intent behind the law is to stifle digital rights and to limit the rights to expression, media freedom, access to information that Sebakade talked about under Article 29 of our Constitution. And now with those examples, we are seeing silencing of online voices perceived as dissenting. And with this law here, it's definitely a gift to Ugandans as a punishment for criticizing government. And you and I are going to be the victims. So we've listened severally to the move of the law. His rationale Honorable Nsereko, his rationale, and he's severally stated that the law is going to, deter the misuse of social media and social media platforms, and perhaps the new clause that the co-speakers have talked about was smuggled because of, the intent he had in his mind. To deter the misuse of social media, which is really broad and quite unintelligible. And further, we've had these claims that the enjoyment of the rights to privacy are being affected by the abuse of online and social media platforms through the sharing of, the unsolicited or hateful or malicious information. I think it's definitely not true, as alleged by a lot of the legislators, who have enacted this law, that existing laws, do not specifically address regulation of information on social media, or that the existing laws are inadequate to address the ills of internet use. Well, just to take a few steps back, the Computer Misuse Act is a 2011 law. So almost a decade or just 11 years in existence. So might it be justifiable to amend it after this decade? Perhaps, yeah, maybe, because one, technology has rapidly advanced over the past 10 years, and maybe aspects of online crimes might have evolved, or my wishful thinking, Parliament may have realized that certain aspects of the old law, which didn't make legal sense at that time, should now be rectified. But none of this has been the thinking, behind the amendment of the law. And definitely we've seen that there's sinister plans by those who have promulgated their views towards the amendment of the law. We probably all see the bigger picture as lawyers and as citizens. The operational environment for the enjoyment of civic rights in this country, especially freedom of expression, is finally closing in Uganda, as we shockingly, witness dictatorial grips that Semakade has been talking about. The trajectory really speaks for itself. If we look at the past 5 years, Uganda's global ranking in terms of, respect of media freedom of expression has been falling at a terrible speed. In 2022, we've been ranked as 132nd out of 180 countries. 2021, 2020, 2019 were ranked 125th, and in 2018 we're 117. So you can see that every passing year there's a decline, and after the passing of the computer misuse law, we definitely are going to shrink further. As Isaac said, we are cognizant of the fact that the computer misuse law is currently being challenged in the Constitutional Court for offending basic aspects of legality and necessity. So what was the urgency for Parliament to expedite the amendment of this law? And this also brings to perspective the frustrating nature of our courts, and the fact that they're impeding human rights with their snail-paced moves. Some of the ULS and I think Unwanted Witness or Chapter 4 challenge this law. And I don't know why the court is dragging its feet in giving us a decision. I'm not sure if it's deliberate, to delay some of these petitions of this kind, but we should have had a decision on the matter before the law was amended. So I'm glad that Isaac gave us perspective as to what has happened, the letters that Uganda Law Society has, written to the DPP to follow up on the matter. But as we can see, really very laid back, and the human rights of this country is really at stake with such mindsets. It's really not in doubt that freedom of expression, coupled with the corollary right to receive, to impart information, is the core value of any democratic society, and it deserves the utmost legal protection. And the question is Uganda a democratic society? If we, listen to the examples that my colleagues have have sort of elaborated. But that said, I believe that freedom of expression is not an absolute right. Yeah, so much as it's very important, we need to know that it's not an absolute right. However, the limitations must fall within the narrow restrictions and the international and regional standards that Uganda has ascribed to. And I think Isaac made mention to this, Article 19 of the International Covenant on Civil and Political Rights. We have Article 9 of the African Charter. I think he also spoke to General Comment 34 from the UN. So these are sort of the normative framework for the enjoyment of freedom of expression across the globe. And Uganda is part of that framework. So the limitation test, which we commonly refer to as the three-part test, should then be the guidebook for Parliament and our judiciary, while dealing with matters of this nature. And for me, to justify any limitation on freedom of expression, the three-part test must be met. So I'll try to summarize what Isaac was trying to expound on earlier on. So one is the restriction provided by law. That's the first leg of the three-part test. And when you read all the cases that he talked about, the Konate case, the courts also apply the three-part test. One is that restriction provided by law. It's not enough for a restriction to be provided by law. For example, this Computer Misuse Amendment Act is provided by law, but does it meet the standards of the first leg of the three-part test? I think it doesn't. Firstly, the law must be clear and precise to meet that standard. This law is all over the place. It's vague, it's imprecise. And I don't think it's drafted with sufficient precision for you and I to foresee or to understand the consequences of what we say so that we can regulate our words accordingly. So on the face of it, the amendment does not really meet the test of it must be provided by law. And I hope that whoever's challenged this act, this amendment in any of these courts, the court will definitely throw out the case on the first leg of the three-part test, that it does not really meet the provisions of, a restriction must be provided by law because it's imprecise and ambiguous. So if you want to sort of understand further what falls within prescribed by law, you could read the case of Sunday Times versus the UK. It's a 1979 law, and it clearly enunciates, the standard on prescription by law. So the second test would be pursuing the legitimate aim. So what legitimate aim does the Computer Misuse Amendment Act pursue? Maybe Isaac will respond later, but one, we have conclusive 5 reasons why restrictions on freedom of expression, access to information can be restricted. One, for the protection of reputation, but like Professor said, why don't we use defamation laws, civil defamation laws? That is sufficient to protect reputation. Secondly, national security, which we cannot go into, but the government always, invokes national security when they want to sort of gag human rights in a blanket manner. The third should be public order. And then we have morals and health. So many of the laws on COVID-19 that restricted freedom of expression would probably fall under health. So the government will claim that, this law perhaps pursues the legitimate aim of protecting reputation of who may be politicians or government authorities. Will come back to that. And the final leg of the three-part test is that it must be necessary for a legitimate purpose. So for me, the question would be, what is the pressing social need for the government of Uganda to amend the Computer Misuse Act? Has the state really demonstrated in a specific manner, the precise nature of the threats that the internet is bringing along, the necessity and proportionality of the, of the actions taken. So we have heard from Dr. That some of the provisions actually have sanctions of up to 10 years, maybe also up to 15 million. So is this proportional? Is the interference proportional to the legitimate aim being pursued? The principle of proportionality has to be respected, not only in the law that frames the restrictions, but also administratively by judicial authorities. So this, for example, if we use the case that Isaac spoke about, Stella Nyanzi, was it really, what was the pressing social need to send her to jail, and was sending her to jail for 18 months proportional to what she had done? And when we look at this law, a lot of the sanctions are not proportional or proportionate to the, to the ills being propounded. So for me, any sane court should be able to easily throw out this bill, or this law rather, because it fails to meet all the legs of the three-part test. Perhaps the second leg maybe, but the first leg, the ambiguities are too many, the necessity is not clear. I think the proportionality of some of the sanctions is beyond what the law, international standards should be, what international standards sort of expound on. And we've heard about the specific provisions, persons without authorization accessing or intercepting your data, recording, video recording another person without their permission, unsolicited information under 26B. But the question is, how do we then balance the rights to privacy and expression? I think Parliament should have been aware, or should already be aware, of the legal standards pertaining to access to information laws. Here, I think we need to look at the extent to which the publication at issue contributes to a debate of public interest. What is the degree of notoriety or vulnerability of the persons affected? What if the personalities are public figures? So what is the prior conduct of the person concerned? If, for example, you have a habitual public figure implicated in corruption, must we seek permission from them to publish information on their latest corruption scandal? This law, for me, I think is here to protect those public figures and politicians from, from their own ills. And when we look at presidential cases like Lingens versus Austria, the standard on public figures, politicians, including other public figures like judges and prosecutors, is clear. Public officials must tolerate a greater degree of criticism than ordinary citizens. And that's because, they do not act in their private capacities. And the requirement of such protection has to be weighed in relation to the interests of open discussion of politics or political issues. So the court in that case, emphasized that the limits of acceptable criticism are wider as regards to a politician than to a private individual, and that unlike a private individual, the politician inevitably and knowingly lays himself open to close scrutiny of his every word and deed by both journalists and the public at large, and must consequently display a greater degree of tolerance. And indeed, words like "you're an idiot," "you're the most useless politician," or the law protects such words. And when there are lots of cases, if you're interested in the standards of politicians and public figures, where the court says that that's value judgment, how do you then measure foolishness? A lot of the European courts decisions normally, where individuals have been convicted in their different countries, the courts have overturned these convictions. So for example, again in Austria, there's a case where a journalist, Oberschlick, called a politician an idiot, and he was convicted. But the European Court overturned that conviction and said, much as the word may sound offensive, the use of such words is justified, if taken in context, and the court also emphasized that conviction of journalists, is in breach of the right to freedom of expression, for use of such words. So, in brief, politicians, public figures must develop a thick skin, and this includes judges, judicial officers, prosecutors, who must be held to this standard as well, because no one forces them to go to those positions. I mean, there'll be an advert, they will apply to become a judge, or they'll go and campaign to become a politician. So they need to rise above the ordinary person and develop a thick skin, and be able to overlook some of these criticisms or insults, and like Isaac said, freedom of expression does not only include words which are favorably received, but it includes those that are, that would shock you, that would disturb you. I think it's high time that our parliamentarians and public figures or politicians, judicial officers as well, understand that they need to step above the ordinary citizen and develop a thick skin. Otherwise, everyone will be going to jail. So looking at the other issue in regards to journalists, this law is going to really affect them, especially those doing investigative journalism. How about protecting journalistic standards, which is in the Media Act, sources and investigative techniques. So you may all have watched the documentary on stealing from the sick, where I think it was BBC and NBS that went out and did an investigative story on how some public officials were involved in the theft of medicines from public hospitals. So with this law, if this law was in place at that time, I think they would have been committing an offense already. And legally, if we look at the legal standards, privacy invasive techniques are allowed. Hidden cameras or undercover reporting must be permitted where there's an overriding public interest, especially in disseminating, information. So I think this law really needs to be challenged, and I hope that the courts throw it out as it should be. As I wrap up, I think provisions like unsolicited information, definitely these offend Articles 41 of the Constitution on Access to Information Law, especially on the guarantee to the right to know in relation to public information. So when we look at the Computer Misuse Act, it's really a law that is an attempt to discourage the disclosure of information by duty bearers, I believe, and this undermines the basic tenets of transparency and accountability. So definitely, I think this law should be thrown out as it is. We've already heard about the Charles Onyango Bo case, and the question there to the legislators would be, why are we reintroducing laws that were decriminalized by courts? Provisions on prohibition of sharing malicious or misleading information. I mean, these offend in every way the ruling of the Constitutional Court in the Charles Onyango Bo case, which decriminalized publication of false news. And I think such laws become irrelevant in democratic societies, although we now need to question if indeed we are a democratic society. I think just a little bit of the Charles Onyango Bo case. When you read, it's a very interesting case, and I think for now it's the most precedential when it comes to freedom of expression, and it makes it common knowledge that it's indeed legal for one to make statements that are considered both, assertions of facts or manifestly deliberate lies, and the court in that case said expression has intrinsic value in fostering political participation and individual self-fulfillment, which this law really takes back, and that the guarantee of freedom of expression seeks to protect not only the meaning intended to be communicated by the publisher, but also the meaning or meanings understood. So the court also clearly came out on its duty to protect freedom of expression, and we are hoping that the panels that will be hearing this case will take that into cognizance and clearly throw out the law. I think I should end there, or maybe just one last thing about hate speech that triggered me when doctor was speaking is that indeed some forms of speech must be prohibited, and I think hate speech is one of them. And when you read the International Covenant on Civil and Political Rights, Article 20 speaks to that. But when we relate that to the Computer Misuse Amendment Act, what constitutes hate speech is sort of different. What's the balance to be struck between freedom of expression and protection against incitement is clearly dealt differently in different jurisdictions. However, the provision on hate speech, if I could just paraphrase, which says, ridiculing, degrading, or demeaning another person or groups of persons, a tribe, ethnicity, a religion, or gender. We have a lot of banter in Uganda, ridiculing groups of people or individuals, and this many times is perceived as humor. So, tribes that are experts in making chapati, tribes that eat people, tribes that eat birds. Are we going to imprison everyone in the whole country? So I think the provision on hate speech should not be conflated with offensive speech, as the right, for me, the right to freedom of expression really includes speech that causes shock and also offends. So I think by and large, the Computer Misuse Amendment Act is clearly a law that needs to go. It does not, it's in this day and era, it does not meet any of the legs of the three-part test, which is sort of the standard on restricting freedom of expression. Thank you.
Well, thank you very much, Catherine, for a very insightful discussion as well, and for sharing your views in respect to the amendment, and also picking up on points from Isaac. For all those who are still in attendance, thank you very much for sticking with us. We ought to have stopped at about 6, but given that this is a discussion that cannot just be glossed over, we needed to give all our panelists ample time to make full and in-depth discussions and presentations. So allow us, please, to extend this to not longer than 6:30, but that's also to allow for any comments and reactions from anybody who might want to share. I see some hands are up, and when we get back from those, we'll have our panelists share their final thoughts. And something that you mentioned there, when you were talking about hate speech, Catherine, was that it's not something that should be encouraged at all, but to what extent. So when we come back, to get your closing remarks from all the panelists, I wonder if there is anything about this amendment that is a positive in your personal views, and if there's anything that it introduces that is positive, but also with the constitutional petition in, and given that court takes its time, considering we already don't have a ruling in the petition in respect to the act, it's the principal act itself, it might take a while before this petition is heard and disposed. So my question to all of you, as when you come in to make your final remarks, is what then is the immediate way to respond, act, and behave with and around the provisions of this law as they present themselves? For members of the public who are not lawyers who are on the call, but also for advocates and lawyers, how best can they work around or work in light of the provisions of this law, now that it's here, up until when the Constitutional Court makes a decision. But before you come in, Tony Tumukunde and Kizito Kasiri, your hands have been up for the longest time. I don't know if you want to speak or make a comment. I could allow you a minute each to make comments, and then we can return to our panelists. Also, thank you for engaging on the chat. To our panelists, you could scroll through the chat room to get some comments and questions so that then you can wrap it up all together. Tony, do you want to speak? I could give you a minute, and Kizito Kasiri. Let's start with Tony.
Thank you, Mercy, Isaac, Tony, and Kathy, and all those that have showed interest in today's discussion. I'll be so brief. There is an author that once stated that if liberty means anything at all, it means the right to tell people what they do not want to hear. And another author stated that I may disapprove of what you say, but I will defend to death your right to say it. And I think those are tenets of free speech in a justifiably democratic society. According to the discussion of Dr. Isaac and Kathy, I have noted few things. One, and there is a problem, a great problem with this law. Most of us, the lawyers on this platform, if you look at the law, it greatly shifts the burden and responsibility of unauthorized access from the attacked to the attacker. If you read that section on unauthorized information, you'll find that the blame and responsibilities directly shifted from the attacked to the attacker. And it also not only criminalizes it also criminalizes expected actions such as unauthorized access, modification, destruction of material. But it also, when you read the whole law, it removes the burden of intent in order to find someone guilty under the law. And I think that was quoted by Kathy very well. In other words, colleagues, I think someone who succeeds in accessing an unauthorized computer, even if he has no explicit intent of doing so, could be at the same time convicted under this act, which is a problem under criminal law. When you look at the whole act, to me, it does not properly define the proper jurisdiction of the act. I perceive that Parliament did not make it with broad or enough inclusion of wide jurisdictional knowledge about prosecuting actions. For example, what happens if there is a conviction set by a court abroad and it must be reciprocated into the Ugandan jurisdiction or by the Ugandan courts? It does not consider that. Lastly, I think, to me, the Act fails to deal with the enforcement aspects of legislation, outlining procedures of trial, search warrants, extradition, and what to do in cases of proceedings of separate international courts. What did Parliament then miss? And I think that was brought up clearly by Isaac. I think Parliament missed the international guidelines and procedures of all countries that have evolved since time immemorial as to computer misuse. Look at the UK, and I think the most restrictive computer misuse laws are in Singapore and Germany. But also, when you look at how Parliament legislated, it failed to consider things like search and seizure to the access, recording and storing new data. It also failed to bring up proper guidelines on wiretapping and interception of telecommunication, which is properly considered into our regulation for interception of communications law. I want to state it very well that you could have good intention, but your legislation might be poorly drafted. I would end my discussion by stating that there is an ultimate need probably for government and Parliament to suppress free speech. And there is an ultimate need for government not want to hear what it wants to hear and not want to agree where it does not actually need to agree with the populace. But all in all, free speech dictates that you may not agree with what somebody says, but you have to defend to death their right to even state and say what you do not want to agree. Thank you so much, Mercy.
Thank you very much, Tony. Thank you for your feedback and your thoughts. You bring up very valid points, and I think Isaac and Prof alluded to some of them earlier. So they'll take note of that in case there's anything to respond to. And one final opportunity to Chizitoka Siri. I will just give you a minute to speak. Shiza, are you there? Okay, maybe not. So if Chiza can't speak, I'll just unmute for Moses Walugembe in a minute, please. Moses, would you please unmute and speak? Okay. Okay, we can't get those. I'll just give a minute to Joseph Bampavura. In a minute, your comments very quickly.
Okay, now I can see the button. Can I come on?
Yes, Moses, in a minute. Just keep it brief.
All right, in a minute. Thank you very much for the discussion, guys. It was a very wonderful discussion. And I mean, I believe the understanding of the law by Ugandan lawyers is really, really good. They're really good. And it's so sad that with all these brains that I just had here discussing, we still live in a lawless country in Uganda. And for me, my issue is with you as a Uganda Law Society. Given the lawlessness evidenced by the institutions that are actually meant to protect the laws that you guys work out hard for, including the police, the army, the parliament and everything, as well as the judges who you work under. It appears all these are NRM cadres. This is a fact because you need to have facts. These people take orders for cases. There is blatant disrespect for human rights, arbitrary arrests, kidnaps, torture of people. Today we just had somebody who died, Naduli's son. He was tortured. We all know he was tortured, taken in and tortured, and now he's dead. And we are doing nothing. So the thing is this: there are kidnaps going on. People are being picked up by the regime. We all know about the drones and everything. This is a lawless country, and people like you who are smart with the law. Don't you think you as a community, Uganda Law Society, are wasting time? And what are you going to do about it? For instance, if you lose on this case that you guys just filed, because the probability is so high that you're gonna lose on this case, because if they just make an order no to the judge, let it pass as it is, and the judge comes and gives a decision that the law stands as it is, what are you going to do? So are you ready for that? What is the plan for Uganda Law Society right now in the current situation of Uganda in response to the days of Napoleon and what they did? I don't know if you know all that history about what was happening back in the day. Thank you very much, otherwise, for the great discussion.
Thank you. Thank you, Moses, for sharing your sentiments. I think you share sentiments with Isaac, who also put out a call to action for members of the Law Society to do more than just talk. So yeah, everyone is in attendance and in hearing. So hope you take up the challenge. One final comment from Joseph Bampavura. Can you unmute, please? Okay. Okay, so for the rest whose hands are up, we're constrained for time, but if you can keep it in under a minute, we can take that. Charles Beinomgisha. No, okay. Or how about Charles Donaldson Ojira? In under a minute, this will be the final comment. Okay. All right, so in the interest of time and so that we can give our panelists a final word on the discussions that have taken place. Allow me to just go back to them. And Catherine, I'll start with you and end with Isaac, our keynote speaker. Any final thoughts and any comments and responses to some of the feedback and responses that have come through? And also just to share your views on what can be done in the shortest, between now and when the court will make its ruling on these questions.
Thank you, Mercy. So my final words would be freedom of expression, just as an emphasis is applicable, not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, and disturb. So very important, words that offend, shock, and disturb are protected by our Constitution under Article 29. And this has been derived from the international normative framework. So when you look at Charles Onyango Bo's case, they extensively relied on international and regional jurisprudence. The Handyside case, which propounds this notion, and other cases across the different regions. So you asked a question about hate speech, and well, the international standard is that any advocacy of national, racial, religious hatred that constitutes incitement to discrimination, hostility, or violence is prohibited by law. But what constitutes hate speech, is very unclear even under international law, which does not define hate speech. But for those who are interested in hate speech, I think we have what we call the Rabat principles on hate speech that clearly expound what should fall within hate speech. And I think this law does not do justice to that because it's quite ambiguous and doesn't fall within that ambit. So going forward, is it a good law? You asked whether there's some positive provisions. I think the duplicity of the provisions, the amendment duplicates existing laws. The Regulation of Interception of Communications Act of 2010 and the Data Protection and Privacy Act, the Access to Information Act. So there was no need to actually come up with an amendment. And as Doctor said, even the provision on children is already in existence. So we don't need a complementary provision. We already have laws that deal with those issues. So it comes back to political will. Do we have the political will to sort of, promulgate laws that defend or promote freedom of expression, access to information, or digital rights in general, because this is where we're all headed to? I don't think so. What we can do before the case is heard, I think there's one case that Isaac has filed in the East African Court. We shouldn't duplicate efforts. So my call would be maybe to file amicus briefs, find people who would be interested in providing the court with some expertise on some of these issues. That would also apply to the Constitutional Court petition, and also capacity building for judicial officers. For over 1 year now, we've been working with judges across Africa to sort of impart, the basic tenets on freedom of expression, the standards while adjudicating cases. What should they look out for? And I must say that some of the judges who have attended these trainings have come out with very good rulings that promote freedom of expression. When we look at the ECOWAS court, some of those decisions that promote freedom of expression within West Africa, those judges attended these trainings. And I hope that we will, sort of get good decisions coming out of Uganda. Some have already come out. I've particularly interacted with some judicial officers who, would tell you, if I had the background on this international normative framework, maybe I wouldn't have ruled that way. So I think judicial officers are individuals like us. They don't know everything. Some people would say it's not our duty to educate them, but I think the more we have people understand the emerging trends, especially on digital rights on the bench, then we shall see some forthcoming and presidential jurisprudence coming out of these courtrooms within the national, regional frameworks that promote freedom of expression within the continent as well. But for me, it's now, it comes back to political will. Thank you.
Catherine, thank you very much for those remarks. I will move on swiftly to Doctor. And Doctor, as you come in, I was reading some of the comments and I read a bit of skepticism about what can come out of the court. There doesn't seem to be so much faith of anything positive coming out of there. So in light of the fact that there is a time factor to be considered, but also a probability or a chance that what might come out of the court may not exactly be what everybody expects or hopes for. May we just hear your final thoughts on some of those things, plus the comments that came through.
Okay, thank you, Mercy. I hope you can hear me.
Yes, we can.
Okay, yes, thank you. So first of all, start by re-echoing what Catherine has said, that in terms of going forward, the best that we can do as people that understand and appreciate this field well and seeing it being stifled is to file amicus briefs. The court should allow us to come in as friends of courts and help give advice where possible. Of course, the skepticism is there and it can't be avoided, but we can only do what the procedure allows us to do. So Isaac has filed this case in the East African court. I know that there's a group of journalists who are also filing before the Constitutional Court here. I mean, beyond all that, we just need to keep pushing with every angle that's out there that allows us a procedure how to trying to solve this situation. So the cases are filed so we can come in and also do amicus, because the government should understand that this is a vague and totally ambiguous law. So it's not really going to target just a particular group of people. It can target anyone, including those who drafted the law themselves. So they need to understand that anyone can fall victim to it, and we don't need it in our legislation now. So thank you.
All right, you're more positive and optimistic, so we'll take that. And we'll come really and finalize with Isaac. Oh, do I see him here?
Yeah, can you hear me?
Yeah. So Isaac will finalize with you, but just before you come in, I want to put our CEO on notice that after Isaac has spoken, I will give him a minute to just close off this session. But Isaac, final thoughts, any final, words or remarks in light of all the discussion that you've been listening on, and in the feedback as well from those in attendance.
Thank you, Mercy. I concur with my colleagues that optimism is necessary at this stage, and the pessimism and the skepticism expressed by some on the call does not cut ice with me. I say so because Uganda, ironically, has always emerged as the bastion of resistance against foolishness of this kind. That is why we have the Obo decision. Our appellate courts especially have always managed to safeguard freedom of expression, whether they have done so accidentally. For some of the observers, that is for historians to assess, but I can assure you that there's a good track record of judicial pushback against political excesses of this kind. I have mentioned some of the cases. I've told you how Severino versus Attorney General is a very iconic case where the court went as far as piercing parliamentary privileges and ruling on decorum. Of course, we have also had punctures along the way, where in the case of Malema Virizi, the court then moved away from the high standard it had set, and began saying that a little violence on the parliamentary floor may be acceptable to pass an age limit amendment. But we all know the circumstance. So I sympathize with those that have that view, but it's good to fight. Eternal vigilance is the price of liberty. We have to be vigilant at all times. I do not agree that we should use only amicus briefs. Please file. Please file. Anthony from the academia, meet somehow and present a suit by academia. They can lock you out. And these nuanced arguments that could come from academia, protecting first and foremost the rights of academia, may be locked out. Journalistic agencies too must file, and so on and so forth. Yeah, that's what I would say. The last thing is until there is nullification or temporary injunctions issued against this law, parts of it, it is important also to up our game at the Standards, Utilities and Wildlife Division. This law is not very much a threat once you understand the infrastructure through which it is enforced. First and foremost, government itself is afraid of bringing people into the courts of law. That's why it uses extralegal or extrajudicial methods. So our approach should be in campaigning against the extrajudicial measures government takes against digital users. They have to be itemized and challenged and campaigned against in their, independently. And then when they disclose themselves in the judicial terms, we should not come too late. As I've said, we should keep a standby legal counsel in the public interest at that court, because that now means that is the gauge for our democracy. We can't ignore the less fortunate when they are being railroaded through this procedure. Lastly, on our own behalf, we are launching the Violence Academy. This will be a citizens' effort to push back against this law, to fundraise, to defy, to protest, but also to get serious researchers and lawyers that can support these efforts. So we shall tell you the details more. We thank the Law Society for this platform. Thank you.
Thank you. Thank you, Isaac, and thank you for your thoughts, but very importantly, thank you for your presentation and your paper. Could you just comment if your paper be shareable and where it can be found, or if not?
What's that?
Your paper, the one that you
presented. Oh, the paper. Actually, these were short notes. I will probably sit down and make a paper out of it and send it to you.
Absolutely. I think that would be very good. But thank you so much for your presentation. To our panelists, Catherine and Dr. Kakoza, thank you very much. To our participants who have held on up until this minute, we appreciate your time and your patience. And I think this is just the beginning of the discussion and the conversation. I think let's take the cue or the call to action from Isaac and the rest, then and take seriously the fact that it is not remote, or it won't remotely affect us, but rather it will affect us directly and immediately. So I guess it's incumbent upon each and every one of us to think about it from that view and direction. There's so many questions, and I think the discussion doesn't end here or now. We can take these discussions in different platforms on different days and different forums, and keep pushing the fact that the society is alive and watchful and is ready to act when called up. So from myself, I want to say thank you to the panelists and the presenters and the people in attendance. And I want to invite the CEO to speak on behalf of ULS in a minute, just to close out this latest in law series. Thank you.
Thank you very much, Mercy. I would like to thank our panelists for a very insightful discussion. The issue of discussion was very timely and concerns all of us, both as advocates and as people in the civic space. Part of our work involves expressing concerns over various things. So either way, this law affects us, whether you like it or not. So we felt it was a timely discussion and one that is close to our hearts. In a special, allow me to thank Advocate Isaac Semakade, Professor Anite, Mercy, and the rest of the team that has been able to put, the team at the Secretary that has been able to put this together. I'd also like to thank the membership for creating time. We had almost a peak of about 900 members online, and the numbers kept on moving up and down, but that was a very good attendance, which shows that these were issues close to your heart. As a society, we undertake to remain relevant and concerned about the issues that affect the membership, and we believe this, among others, is a step in that direction. Thank you very much for and forgive us for stretching this long, but thank you very much and have a pleasant evening.
Thank you, Mr. CEO, and thank you, gentlemen, ladies, and everybody in attendance. It's been a pleasure having you. Have a good evening.